Hello and welcome to Job Law. I'm your host, Joe McGregor from Dallas, Texas, and today we're going to answer the question, who pays for what?
Any material communicated on this podcast is for general informational purposes only and is not intended to be legal advice. Nothing herein should be considered to create an attorney-client relationship. Please consult an attorney for legal advice on your matter.
Today's episode is one of those questions that I get all the time, and I'm kind of amazed at myself for not realizing that this might be a useful podcast episode because it gets asked so frequently. Now, what happens in a practice transition is that a seller is going to have some expenses related to selling. Most of those expenses are going to relate to the team that the seller brings on to help him or her sell that practice. Most of the expenses that relate to a buyer are going to also relate to the team that buyer brings along. It is pretty obvious, I think, for most people, and I stress most because it's not obvious to everyone, but pretty obvious to most people that those team members that you hire or retain, however they're paid, they are paid by you. If you're the seller and you hire a lawyer, you are going to pay that lawyer. If you are a purchaser and you hire an accountant to help you do financial due diligence, you are going to pay for your CPA. It is not as uncommon as you would think to have clients or parties want to have the other party pay for their people. Now, before I go any further, let me articulate two times where people are asking for the other side to pay for their people. Number one, sometimes we're going to see a distressed practice. This is somebody who's selling a practice who is not going to make any money. In fact, maybe they're coming out of pocket, and they may ask a buyer to help subsidize some of their expenses so that it costs less. It's not that common, but it happens. The other situation is just negotiation, right? Like some people will say, I'm the seller and you're the purchaser, and if you will get an attorney, then I will help pay for it, or something like that. It's not common, but I get asked that question. Can I get the seller to pay for my attorney? I guess you could ask. It would be very unlikely that they would be interested in doing that. And I do hear people, especially purchasers, who will say, I've got to spend a lot of money to buy this practice. The seller should help out. Bear in mind, the seller is also spending a lot of money. And that segues into really the heart of this episode. And that is, well, who presents what? And of course, who pays for whatever is presented. And what I mean by that is when you're doing a deal, step one is going to get a valuation. This is usually handled in the traditional sequence of events. You're going to have a seller who's going to want to take his practice to the marketplace. In the olden times, which is just not very long ago, it was par for the course to go get a broker. And that broker was going to conduct a valuation. I can hear people making comments about the value of those valuations. Sometimes they were very useful and sometimes they were less useful. And very rarely were they independent third-party valuations. Because of this, a lot of times those valuations were free. The seller just wanted to have a tool with which to price the practice for the marketplace. But that came at the seller's expense eventually because the seller's hiring the broker and the seller will pay the full entire amount of the broker fee. That's between the broker and the seller. On deals where there is not a broker, it's a little less clear. Usually, the valuation is paid by whomever asks for the valuation. So if a seller says, my practice is worth $1 million, and the buyer says, I kind of doubt it, then the buyer is going to have the onus to go get a valuation and see what that price really is. Often it is the case that a buyer and a seller will get together and say, let's go get an independent third-party valuation, and we will, pinky swear that we'll honor whatever price they arrive at. That happens. I have found that sometimes the real issue there is finding an independent third party who will give you a reliable valuation. The next step in a deal is the letter of intent. Also, a little twist because, whoever wrote the rules on deals, theoretically, the buyer is presenting an offer. So the buyer hires an attorney to put an LOI together. In reality, most people are going to put forth LOIs on a template that's supplied by the broker or one that they find online. Often people aren't even using attorneys. And I'm not advocating that. Obviously, as an attorney, we would love to be involved as early as possible. But it is the case that a lot of people are putting these LOIs together without the assistance of an attorney. I only mention that because they're maybe not making an expense yet at that time, at least not on law. Maybe on a CPA at that point, but not on law. But still, you're responsible as the buyer for producing that letter of intent, even though in real life, like I say, deal to deal, it may be different. Now on to the real heart of the issue, which is the purchase agreement. It is the case that, 95% of the time, it is customary that the seller produce the purchase agreement. There are reasons that the seller produces that. Historically, we expect that the seller spends about 3 times as much as the buyer on legal fees, partially because they are paying to have the purchase agreement put together. And again, oftentimes, these purchase agreements are template documents of convenience provided by brokers. So they're not actually spending all that money. Even if they have an attorney, the attorney's not putting the document together. They're reviewing it on behalf of the seller. But nevertheless, the seller pays for their own attorney to do that review or to work up that agreement, and the buyer pays for their own attorney to review it. But if you're getting into a deal and you're wondering, okay, now that I've signed the LOI, what's my next step? Well, the next step is that seller putting together that purchase agreement, whether it's the broker or the attorney. And then finally, there are some various costs that may or may not be present in your deal. Number one, probably the more common one, are escrow fees. Escrows are not standard on deals, but they do get used. They're not uncommon. Kind of depends on who's involved, depends on the complexity of the deal, and maybe some other factors like liens and trust might be a factor as well. But if it has real estate, it almost positively will have an escrow. And if it does not have real estate, it's pretty common that it doesn't. But if there is escrow, the most common scenario is that the parties split the fees. Doesn't always happen that way, especially if one party requests escrow and the other party doesn't feel it's necessary. Escrow is really not that expensive. Escrow fees aren't terribly high. So it's not something that we typically will fight too hard over, may push back a little bit on that. But if we're buying $1 million practice, escrow fees they're not going to move the needle very much for us. Closing costs are something that get referenced in purchase agreements all the time. But usually there's not a lot of closing costs because a lot of deals aren't using escrows, and that's the main closing cost. There might be closing costs for escrow officers to perform certain tasks like lien releases and things like that, but it's not that common. And a lot of times these tasks are handled outside of the concept of escrow. But in that case, lien releases, those are going to be the responsibility of the seller. So the seller would carry those costs. There are 2 other fees that pop up. One is something we call transfer fees. Everybody's familiar with this at some point if they've ever rented. But sometimes you have to pay $200 deposit to turn the water on, or for the phone to flip on, or whatever. There are these transfer fees that you may incur to switch that service over to the buyer or the seller, chiefly the buyer from the seller. And those costs are simply negotiated. In a perfect world, maybe we would argue that they should be split, but that's not always the case. If the seller had to pay those expenses when they bought the practice, they're going to be probably inclined to have the same arrangement when they sell, and vice versa. If they started the practice, they're not going to have that frame of reference, so they might be inclined to split those transfer fees. But again, especially modernly, we've seen a decrease in transfer fees, and they're usually not as frequent or as high as we've seen them historically in the past. And then the other one is taxes. This is going to be one that is very specific to your state. Some states have transfer taxes and some states do not. The way you think about this is like the grocery store. You go buy some product at a store. If I'm going to go to Best Buy and I'm going to buy a TV, I'm going to have a sales tax. In that case, the price that they've advertised, it does not include sales tax. And when I go to the cash register, they're going to charge sales tax. That's going to be above and beyond. I'm going to pay it even though Best Buy is responsible for remitting that to the state. They have the obligation of remitting it, even though I'm the one who funded it. And I would say that in most dental deals, that where there are sales tax, and the good news is that most states do not charge sales tax on bulk transfers like this, one-time bulk transfers. Some do though, so be sure you're aware of what your state does, and make sure your attorney is aware of what your state does, mostly because of timing. Some of these require some advance notice, and you're not going to meet your close date if you're not aware of this. And at the last minute, you try to get a tax clearance letter from the Commonwealth that you're in, and they say, yeah, we'll get this to you in 3 weeks. You are going to be very disappointed. Make sure your attorney understands this. But I would say that the majority of the deals that we've seen, the seller will pay that tax. And the good news is that, these are going to be percentages. They're not usually crazy expensive. I've even been surprised. I'm like, that's not so bad. But anyway, that's who pays for what. So at the end of the day, one thing to remember is your team, your expense, your benefit, your expense. And to the extent something benefits the both of you relatively equally, then you will most commonly split it. But at the end of the day, has a lot to do with leverage. So there you go. I just wanted to lay this out. We get this question all the time. And those are the general market customs for who pays for what. Thank you so much. We will see you next time.